Happy birthday, everyone, from all your friends on Sesame Street.
See it all at the zoo. The Louisville Zoo.
You have the best seat in the house for quality television with Channel 15. TV worth watching.
Funding for this program was provided by the Corporation for Public Broadcasting and by the financial support of viewers like you. From Capitol Hill, hearings on the nomination of Clarence Thomas to the Supreme Court.
Good morning. I'm Paul Duke of Public Television.
And I'm Nina Totenberg from National Public Radio.
And we're back once again with our live PBS NPR coverage of the hearings on the nomination of Judge Clarence Thomas to take the place of Thurgood Marshall as a justice on the Supreme Court. This will be day 3 for Judge Thomas in the witness chair. He began his testimony on Tuesday. This being Thursday, he will be, we expect, once again in the witness chair all day long. And Nina, thus far, what we can say is that Judge Thomas is certainly not saying very much about the volatile issue of abortion, but on certain other issues we are learning more about his views, and we're learning that he has a rule of flexibility about some of those views.
Well, what he's done is back away from some of the more controversial views that he's expressed over the years. And as we've heard repeatedly, I guess perhaps the most significant statement that has been used against him that he has disavowed was a reference that he made to an article by conservative Louis Lehrman. And in that article, Mr. Lehrman suggested that a fetus, an unborn child, has a right to life that is the supreme value under the Constitution, and that therefore any abortion would be a violation of the Constitution. Now, Judge Thomas, when he was chairman of the EEOC, praised that article as a splendid example of natural law. It was used by his opponents as an example of evidence that he would vote to reverse Roe versus Wade. When he came before this committee this week, he disavowed that article, that statement, and said, well, I was really only referring to the general concept of natural law, the general idea that I was trying to get a conservative audience to understand that natural law should be used in the context of racial discrimination. Well, senators have increasingly questioned that statement and others like it. Yesterday, Patrick Leahy had a long exchange with Thomas in which Thomas said that he had personally never expressed a view on Roe versus Wade and didn't have a view on Roe versus Wade and had never had a discussion about Roe versus Wade in the year it was decided, for example, 1973 when Thomas was in law school, or any serious discussion about it since then. And we now see senators, Democratic senators, some liberal Democratic senators, are clearly building a case for a credibility gap. And I think what surprised me, Paul, is that I think that there is some indication that there is more opposition on this committee from liberal Democrats than I had expected. I think there may be as many as 5 or 6 votes against him. At least it's leaning in that direction right now. They think they have something to hook onto, and it's his lack of forthrightness as they view it.
That's certainly the case, and in just walking around during the breaks yesterday and talking to some of the committee members and some of their aides, it was clear that they were disappointed in some of the answers being given by Judge Thomas. They felt that he was backtracking, that he was repudiating some of the positions which he'd taken before, and I think what emerged from my conversations with these people was that they don't have a clear picture now of Judge Thomas, of where he stands, of what kind of justice he would make. And they feel that there is developing here an issue of his own credibility, because they feel, as somebody said, what we're getting is a new Clarence Thomas at these hearings.
Of course, if he were to embrace those past statements, they would probably vote against him based on that, saying his views were radical.
Well, that could well be. Now, from Judge Thomas's standpoint, we have to say, I think that he is trying deliberately to present to the committee a more moderate, a more flexible image. political standpoint, you can understand what Judge Thomas is trying to do. We're standing by waiting for the hearings before the Senate Judiciary Committee to resume. This is the third day of testimony by Judge Clarence Thomas. He'll be in the witness chair. Now, there's a slight delay this morning because the committee is meeting in executive session to take up certain panel business relating to judicial nominations. That's one of the functions of the Judiciary Committee. It receives nominations for judgeships, federal judgeships around the country, and then it acts on those nominations. And I believe that's what the business at hand is this morning. The senators, the 14 senators of the Judiciary Committee, are meeting in private session, executive session, as they call it on Capitol Hill. When that's over, then they will resume the open session, the hearings on the nomination of Judge Thomas to the court. One of the people who's been sitting in the hearing room following the proceedings for the 3 days is Stephen Roberts, who's joining us now. Steve is a longtime Washington reporter, first with the New York Times, and now with U.S. News and World Report. And Steve, what impressions do you get of the hearings thus far from having a ringside seat?
Well, a couple of interesting impressions. First of all, as you say, Clarence Thomas is a very programmed nominee. I covered 2 years of the Reagan White House, and I feel like I'm hearing the same kinds of things that you used to hear from Ronald Reagan, the note cards flipping up with the same statements over and over. Clarence Thomas at times sounds also like someone who's taking the Fifth Amendment. You know, I decline to answer that question, Senator, on the grounds that it'll tend to incriminate me, which of course is exactly what it would do, is incriminate him if, as Nina said, if he told us in some ways what he really thought about some of these things. He is very programmed, and that's because of the game plan, as we've been discussing, for days. The game plan is say as little as possible, don't give the opponents anything to shoot at. In some ways, I think they're doing Judge Thomas a disservice when they do that. Because in these rare moments, when we've seen his true personality show through, he's a humorous, lively, interesting person. But we've seen very few glimpses of that. Most of the time, we're seeing this very dull, programmed, unimaginative performance.
But it does strike me that he comes across sitting in the witness chair as an engaging person, a friendly man. He seems to have established, at least during some of the breaks, a certain rapport with the senators, which has not always been the case with certain nominees who've appeared here.
Well, that's true. As I say, Clarence Thomas is a very engaging man personally. Anybody who knows him will say that. And he's known these people a long time. People forget that he has appeared 50 times before congressional committees, including often in front of the Judiciary Committee. He's been 4 previous confirmation hearings. He's no newcomer to this business. He's known these senators a long time. So he does have a rapport with many of them. But his performance, I think you're right. I think a lot of the senators are disappointed that they didn't expect much more, frankly, but they are disappointed that they are not getting a fuller exposition of his views and the kind of justice he might do.
One of the things I think we should note is that Clarence Thomas has not had that much legal experience. He's been on a federal appeals court here in Washington for, I think 15 or 16 months.
Yeah, a little more than that. I think 18 months, something like that.
No, he has not had very much experience, and that shows. There are often the reference to cases. He doesn't seem to have much of a view on a lot of the legal issues that are coming up, even though he's been cramming for this for months, and it's like a postgraduate course in legal education he's been taking for the last couple of months.
Steve, do you think that this strategy that the White House has adopted, which is a repeat of the Souter strategy that works so well, it strikes me that it works less well with somebody who has a track record, that with a stealth nominee like David Souter, it was a perfect strategy. And that you can't always just tailor the same strategy to a different guy. And the Democrats found that out after they successfully beat Bork. Then they tried it on the next nominees, and it just didn't work. Anthony Kennedy came up here and said, I believe in a right to privacy. And they all lay down and said, thank you, and then turned around and were very upset when Justice Kennedy voted against the right of abortion.
Well, this is a repeat of the Souter strategy. You hear over and over again, the ghost of Robert Bork hangs over this hearing room, and literally the ghost, having been slain by this committee. And and he is, and they will not repeat the same, what they believe, a fatal mistake, which is allowing Judge Bork to say too many things about too many controversial issues.
Well, one of the things that occurred during the Bork hearing, which Bork's supporters now recognize as a mistake, was that he decided to do an intellectual tap dance with the senators. And I think it's quite clear that Judge Thomas has been coached not to get into that sort of thing.
Absolutely, because if he answers one, he looks kind of foolish in some ways at moments when he says to Senator Leahy yesterday, well, I never even thought about Roe v. Wade.
Right.
Now, no one in that entire room believed that answer, including Judge Thomas.
And with Robert Bork, it was the opposite. Bork almost explained his philosophy, his views about the law too much.
Well, that's right, and he provided a lot of ammunition for people to oppose. The one thing that, as you were saying earlier, the one thing people can say about Thomas is he has not been forthcoming. That's not as good a case as being able to point to specific things that you're afraid of. And I think there will be Democrats who will vote against him. I'm not sure it'll be as many as 5 or 6. The frustration level is high.
I won't bet with you yet, Steve. Give me another week, then I'll bet with you. I'm just saying that's the direction it looks like.
You know, one of the interesting elements of this hearing, we've heard a lot about the politicization of Supreme Court nominees. And, of course, last week there was a whole flap about the advertisements being run here in town attacking, by conservative groups, attacking 3 of the Democrats. One of the interesting things we've seen this week is a further elaboration of the political nature of this process. For every journalist like myself who walks out of that hearing room, you are besieged by representatives of both sides trying to give you their spin, this phrase that we've come to know in politics, spin doctor, which really started after the presidential debate. You'd walk out of a presidential debate and both sides are saying, we won. No, we won. Exactly the same thing is happening in here.
Listen, we're just outside the hearing room itself, and we're being besieged by staff aides who come over and they're offering their senators, and they want their senators to get their views across about their positions, particularly if they're strongly pro Clarence Thomas, or if they have certain doubts about it.
I mean, it was fascinating. The first day, people rushed out, and you had Senator Danforth, Thomas's leading supporter in the Senate, saying, it's 20-0 after the first inning. And you had 5 feet away, you had Ralph Neese, the chairman of the director of Leadership Conference of Civil Rights, saying, we've proven we have a real chance to beat this nominee, 5 feet from each other.
Well, this underscores, doesn't it, the fact that these fights over Supreme Court nominations are being waged these days like political campaigns.
Well, and one of the interesting things that has happened, we're sitting here in the office building right next to the Capitol. And what people are trying to do is get their message out through the media, through us and all the other hundreds of reporters here, back out to the country, stirring up sentiment, stirring up interest and support or opposition, and having that message bounce back to this very building, to this very complex, to try to influence the senators. So you can almost imagine it physically, that message going out and bouncing back. And that's been increasingly the way legislative battles and political battles are fought in Washington, trying to use the media to generate public support one way or another.
We're standing by, we'd like to remind you again, for the beginning of today's session of the Senate Judiciary Committee. There is an executive committee meeting taking place now. The committee taking up certain panel business. And when that's over, and we expect it to be in a few minutes, we'll be going to the hearings to continue our live public broadcasting coverage.
You know, one interesting thing, Paul, is that it's really quite new for us to be at these hearings. The first time that cameras and microphones were at Supreme Court confirmation hearings was Justice Sandra Day O'Connor's hearings in 1982. The first Supreme Court nominee ever to come before the Senate Judiciary Committee was Harlan Fiske-Stone in the 1930s.
1925.
1925, thank you. And
You weren't here, of course, Paul.
Yes, and
quite.
he did not answer any questions. The first nominee to answer questions was Felix Frankfurter in the 30s. And this process has evolved over the years, and only in the last decade, less than a decade, have we become part of the equation. And I'm sure there are people who will argue it's not a good thing, but after all, this is the least accountable branch of government. It does strike me that the public ought to be able to see what happens at a confirmation hearing.
And it continues to evolve. As I said just a moment ago, it's now become a political campaign. such a noted jurist as Earl Warren, who was the Chief Justice, he did not testify. At his confirmation hearings, it used to be that some of the people who were nominated would come up to the Capitol and they would sit outside the hearing room or in a nearby room, and they would be on call if the senators wanted to ask them something. But if you go back to the 19th century, what you discover is that the hearing process was practically non-existent. Nominations were routinely submitted by presidents. There'd be a brief consideration. They might be accepted, or they might be...
And routinely opposed sometimes for rank political reasons.
Incidentally...
There's a reason why, though, Paul. In addition to the technology, which, of course, we've been talking about, that allows the whole country to watch these nominations, I think another reason why this becomes so intensely political is because we are living in an era of divided government. The executive branch has been in the hands of one party for 12 years. The Congress has been in the hands of the Democrats for almost the same length of time. We have a deadlock in the governing process. And therefore, more and more attention in this town is focusing on the Supreme Court as the place where decisions get made, because there is such a balance in the other two branches of government. And you see, one of the reasons for the intensity of these groups that are trying to get our attention and getting the country's attention is because the Supreme Court seems to be the balance wheel increasingly.
Well, that's exactly right. And what you find now is that the Republican Party has captured two of the three branches. They have the executive branch. They've had the presidency since 1980 continuously. There is only one Democratic appointee still left on the Supreme Court, and that's Justice Byron White, who was named by John Kennedy back in 1963. So...
one of the reasons why, we were talking earlier about why there's so much intensity over this nomination, and yet we remember back to Judge Bork, when in some ways it was even more intense. And at that moment, Judge Bork was the fifth vote, not the sixth or the seventh to tilt the court. We got to remember back to 1987, the Democrats had just won an election in '86. They had taken back control of the Senate. And they were feeling kind of feisty. Maybe the last time in Washington they felt that way.
And the Iran-Contra affair had just happened. The Reagan administration was extremely vulnerable. The presidential election was coming up. The Democrats thought they had a chance of winning it and putting their own people on the Supreme Court. It was an entirely different era.
atmosphere.
And you had a sense, if you could have defeated Bork, that maybe if the Democrats then took over in '88, that you could have blocked this conservative takeover of the Supreme Court. Remember, in 1968, that's exactly what happened. When Lyndon Johnson tried to put Abe Fortas as Chief Justice and name another associate justice, and when the Republicans stopped that process, they then were able to win the election in '68 and nominate someone else, Warren Burger, to that Chief Justiceship. So the Democrats in some ways were thinking that, and that explains one of the reasons why there was such an intensity over Bork, and as important as this one is, the feeling is not quite the same. I think the Democrats in some ways are disheartened. They know not only are they now 6 or 7 conservative votes, but they're not going to win in '92 either, and by the end of Bush's term, the Republicans will have nominated probably all 9 justices.
I just want to put a caveat in here so we don't all end up looking like monkeys someday. And that is that I've sat through maybe even more of these things than you guys. And although I would still say that Clarence Thomas is a shoo-in for confirmation, we have to remember that this is like the World Series of a baseball season, and anything can happen in a ball game, and has. At this point in G. Harold Carswell's confirmation hearing, he was a shoo-in. It was really only after he was off the witness stand that new evidence came up that suggested that he had not been truthful with the committee. And then, in a very close vote, he was defeated. And even the Fortas situation. Initially, the conservative opposition to Fortas was viewed as just political and not going to be successful at all. And then it began to gather steam and was successful in blocking his promotion as Chief Justice. And, of course, he was eventually forced off the court for ethical reasons.
Well, that illustrates an important point, namely that the hearings, whether they be hearings on a Supreme Court nominee or hearings on legislation, hearings always have a life of their own, and the unexpected, the unpredictable can occur, and things can arise, new information, new knowledge develop that will change the course of events. And that's exactly what happened during the Carswell case, as you mentioned just a moment ago. And again, to repeat, it was not unusual It was not unusual back in the 19th century for the committee to turn down Supreme Court nominees. As a matter of fact, one of every four was rejected back in the 19th century. Well, I understand that there's some stirring in the committee room. There's Senator Herbert Cole, who has arrived to take his seat, and he will be the lead-off questioner, and Judge Thomas is in the witness chair, so we're going to go to the hearings.
That you were, quote, involved in mock committee sessions in which your answers were tried out in front of lawyers pretending to be committee members. My question is threefold. First, who played me? Was it Kevin Costner or Mel Gibson? Second, I'd like to know who played Senator Metzenbaum? And third, Judge Thomas, I'd like to know who could possibly have played Senator Simpson.
That's a good question, Senator. I don't remember precisely, but I think that it may have been Senator Danforth who played all three. But I can't remember precisely.
Judge Thomas, I'd like to ask you why you want this job.
Senator, being nominated to the Supreme Court of the United States is one of the highest callings in our country. It is an opportunity, it is an entrustment, an entrusting of responsibility by the people of this country, by this body, to make some of the most difficult and important decisions in our country. It is an opportunity to serve, to give back. That's been something that's been important to me. And I believe, Senator, that I can make a contribution, that I can bring something different to the court, that I can walk in the shoes of the people who are affected by what the court does. You know, on my current court, I have occasion to look out the window that faces C Street. And there are converted buses that bring in the criminal defendants to our criminal justice system, busload after busload. And you look out and you say to yourself, and I say to myself almost every day, but for the grace of God, there go I. So you feel that you have the same fate, or could have, as those individuals. So I can walk in their shoes, and I could bring something different to the court. And I think it is a tremendous responsibility, and it's a humbling responsibility, and it's one that, if confirmed, I will carry out to the best of my ability.
All right, that's good. Judge Thomas, if I understand you correctly, you're going to leave behind most all of your views about what type of society we ought to be and what type of policies we ought to apply. And two questions. First, why after 20 years in the forefront of these battles do you want to leave all of this behind? And second question is, if you do leave so much of this behind, what's left?
Though it may sound rather strange to some individuals, the kind of fighting and the infighting that certainly the difficulties of battle, those kinds of battles in the political process, I think, are wearing. And so it's not the confrontation that I ever relished or enjoyed. In fact, that is the opposite of my personality. I like to try to find consensus. So I don't miss and have not missed on this court having those kinds of battles. We have reasoned, constructive debate on the court. But with respect to the underlying concerns and feelings about people being left out, about our society not addressing all the problems of people, I have those concerns. I'll take those to the grave with me. I'm concerned about the kids on those buses, I told you. I'm concerned about the kids who didn't have the strong grandfather and strong grandparents to help them out of what I would consider a terrible, terrible fate. But you carry that feeling with you. You carry that strength with you. You carry those experiences with you. I don't think you have to carry the battles with you. It's a different way.
All right. Judge, I'd like to come back to a question about preparation. When I was running for the Senate, I worked with people who helped prepare me for debates. So in my mind, there's nothing wrong with getting some advice and help in preparing for this hearing. But I'd like to ask you some questions about the process. When you were holding practice sessions, did your advisors ever critique you about responses to questions in a substantive way? Did they say, for example, quote, you should never soften that answer, you should soften that answer, or don't answer that question, just say that you can't prejudge an issue that may come before the court?
Senator, the answer to that is unequivocally no. I set down ground rules at the very beginning that they were there simply to ask me and to hear me respond to questions that have been traditionally asked before this committee and other hearings, and to determine whether or not my response was clear, just to critique me as to how it sounded to them, not to myself, but not to tell me whether it was right or wrong or too little or too much.
Good. Judge Thomas, most Americans believe that the Supreme Court should have a fierce independence. Do you see any problem in terms of the system of checks and balances and separation of powers and having members of the executive branch detailed to assist in the confirmation of a member to the Supreme Court? Do you think that such assistance creates an appearance of impropriety because it blurs the lines between the branches of government?
Senator, the process of confirmation, as you can imagine, is a difficult one. The last 10 weeks have involved my answering countless questions, responding to significant document requests that I personally could not respond to, and information that was contained in the executive branch. Traditionally, individuals in the executive branch have assisted, but again there, I made it clear what my rules were. They were to do nothing more than provide me with information such as case law, documents that I needed to prepare myself at my request. They in no way did anything more than provide that information. For example, they would be more in the order of what I would have my law clerk do, provide me with the material that I need.
Well, but it said in the New York Times, where they misquoted, that there were mock sessions between you and people from that branch during which questions were asked and answers were given. That's entirely different from what you just said.
To my knowledge, there was one individual from there were a number of individuals from the executive branch, that's right. I thought you were talking about the individuals who assisted me with the documents, not the individuals
No, we're
in the mock
talking about
session.
the whole process, the preparation, the involvement, the fact that the executive branch and you have been working together on this nomination in all the various ways, including preparation for this hearing. And I'm asking you not whether or not you have the right to do what you do.
Yeah.
I'm asking whether or not that blurs the separations that are supposed to exist between the branches of government.
Sorry, I wasn't responsive. I think that there would be certainly no more conflict than one would have when a clerk from your staff argues before you in the subsequent years. I don't think there would be, Senator. I can see the concern, but I don't think that there would be at all.
All right.
And the preparation is dearly needed. The help, the assistance is dearly needed.
Good. Judge Thomas, I'd like to talk to you about the right to privacy for just a minute. Yesterday, you told Senators Leahy and Metzenbaum that you had no opinion, either personally or professionally, about the legal issues raised in Roe, and that you have never had an opinion and never discussed it. That is a very strong statement to make to this committee and to the American people. I'd like to ask you a related but non-legal question. As Clarence Thomas, the man, the human being, do you have a personal view on whether society ought to provide women with the option of having an abortion?
Senator, I would essentially reply as I have yesterday, and that is this, or in this way. I think that in this area that the need for a judge such as myself to maintain impartiality is critical. I think that whether or not I have a view on this important issue is irrelevant to being an impartial judge, and having one could undermine or create a perception that could undermine my impartiality. That is very important to me, and I think it's critical, if not important, to any other judge.
That's fine, but the question I ask is whether you have, as a human being, a personal view on the subject.
Senator, I understand the concerns on both sides of the issue. I'm certainly a citizen who attempts to keep abreast of the news and to be aware of the issues in this country. But as I indicated before, that whether or not I have one, I think is irrelevant to my being impartial or considering this issue as a judge.
Judging you is all white and all male. Do you think that your responses on this question would have satisfied a panel composed of 14 women instead of 14 men?
I don't know, Senator. I would hope that the manner in which I am judged in a fair and impartial manner does not depend on the gender or the race of those judging me.
In 1987, Judge Thomas, you said that you believed, and I quote, "Our civil rights policy should be based on fundamental principles and on the assumption that Americans are basically decent and that they prize fairness," unquote. Yet you told Juan Williams for an article in the Atlantic Monthly that you believe that the white world is wrought with racism, and I quote, "There is nothing you can do to get past black skin. I don't care how educated you are, how good you are at what you do. You'll never be seen as equal to whites." Judge Thomas, those are contradictory statements, and I'd like to ask you how you can oppose most forms of affirmative action if America is basically racist. And second, how can you support any type of affirmative action if Americans are basically decent and fair, as you suggested?
Senator, it's clear from the testimony that I've given you here about where I grew up that I understand the realities of our country. It should be clear from my biography that I understand that racism exists throughout my speeches. I've made it clear that there is unfairness in speeches at commencement, Savannah State College, Compton, wherever, places that I have had occasion to speak to minority students, to others. I've pointed out this unfairness, but I appeal There is an individual I heard recently who said that we can seek revenge or prosperity. I have tried to appeal to that which is good. I have been there where I have been angry and upset. And I understand what it means to be angry and upset. But what I have tried to do during my tenure at EEOC, during my public life, recognizing that there are these contradictions in our society, I have tried to appeal to what is good, what can move us forward, not backward. With respect to affirmative action programs, I tried to explain yesterday the tensions between the notion of fairness to everyone and this desire to help people who are left out. There is a tension. And how far do you go in trying to include people who are left out and not be unfair to other individuals? And it's one that I had hoped that we could wrestle with in a constructive way. But as the debate went on, unfortunately, we were not able to, and the rhetoric was heated. But I have initiated affirmative action programs. I've supported affirmative action programs. Whether or not I agree with all of them, I think is a matter of record. But the fact that I don't agree with all does not mean that I'm not a supporter of the underlying effort. I am, and have been my entire adult life.
All right. Judge Thomas, I'd like to talk about a subject which is somewhat sensitive, but it seems to me we ought to address it openly. In the article by Juan Williams, you said you were troubled with the possibility of being selected for a position because of your race. In that instance, you were speaking about your appointments to the head of the Office of Civil Rights, at Education, and also to head the EEOC. Did you have similar thoughts when you were nominated for the Supreme Court, Judge Thomas?
Senator, my concerns were in being selected for the two positions that you stated was that I sensed that it was automatically assumed that since I was black, these are the positions for me. It's expected that I would go to that sort of a position as opposed to the Energy Department, for example. The president indicated that he nominated me because as a result of his search, as limited or as broad as it may have been, among those individuals, he felt that I was the best qualified. I take him at his word. But I also believe that there is a need in all of our institutions, on the Supreme Court and elsewhere, in diversity. I think it's important to our society.
Well, are you troubled by what mainstream periodicals have been saying now for several weeks? I quote just one U.S. News and World Report. They said that you were picked from a pool of one to fill a quota of one. That's been said in its way by a half a dozen or a dozen mainstream periodicals around the country. Does that bother you?
Senator, there is much that has been said over the past 10 weeks that has troubled me. To say that that is the most troubling thing that's been said, I think would not be accurate. But that would trouble anyone. And I think it is inaccurate.
Judge Thomas, you've had some harsh things to say about Congress, so have I, and so have most of the American people. But unlike most of the American people, you have worked in the Congress. In fact, you've worked in the executive, legislative, and the judicial branches. I'd like to ask you a few questions about your experience in these areas. In a 1988 speech at Wake Forest, you said that legislators did, quote, browbeat, threaten, and harass agency heads. In the Wake Forest speech and in another 1988 speech at Sun University, you said that Congress was, and I quote, a coalition of elites which failed to be a deliberative body which legislates for the common or the public interest, and that Congress was, quote, no longer primarily a deliberative or even a lawmaking body. So, Judge Thomas, why would a man like you, with strongly held ideas about public policy, ever want to work in this branch of government, the courts, where you have an obligation to uphold the bad laws that you say Congress makes?
First, let me go back to the position that I was in as a member of the executive branch. As I indicated yesterday, there is tension between the two branches, and particularly in the oversight process. I felt, as the head of an agency who had been called to the Hill on a number of occasions in some very difficult circumstances, that particularly some of the staffers went too far in micromanaging the agency and made it very, very difficult. I think that the legislative role of Congress, as well as the oversight roles of Congress, are very, very important. And it's a little easier to see when you're not the object of an oversight hearing. In my current job, our role is to determine the intent of Congress. I believe that I have done that fairly and impartially, and I've stated very clearly that my job is not to engage in a policy debate with Congress. I'm out of that role. I'm not in a political branch. I'm in the neutral branch, and my job is to remain neutral. When I was in the political branch, I think I fought the policy-making battles, right. And I'm sure that individuals on this side had some...
I just want to go back and quote you what you said, and is that a fair... Do you remember saying it? Is it true? Do you believe it? You said that Congress was a coalition of elites which failed to be a deliberative body that legislates for the common good or the public interest. And you said that Congress was no longer primarily a deliberative or even a lawmaking body. Is that how you feel
today?
Today. Here, sitting before 14 of us who are going to vote.
I can't, Senator, remember the total context of that, but I think I said that, and I think I said it in the context of saying that Congress was at its best when it was legislating on great moral issues. Now, I could be wrong. I think I've turned over 138 speeches, and I can't remember the details of all of them. But I did say, and I do remember saying, that Congress was at its best when it was deliberating the great moral issues of our time, such as, for example, our involvement in the Persian Gulf conflict.
Right. Judge, I'd like to briefly follow up on Senator Simon's church state questions. During your appellate court confirmation hearing, we discussed your views on school prayer and asked you about your 1985 statement where you said, as for prayer, my mother says that when they took God out of the schools went to hell. She may be right. Religion certainly is a source of positive values, and we need to get as many positive values in schools as possible, quote unquote. You said that was your personal view, but of no consequence that as an appellate judge you would be bound to follow Supreme Court precedent. Now, however, you're being considered for the Supreme Court, and you will be in a position to set precedent. So your personal views are of great consequence. So we'd like to ask you this. The Supreme Court has repeatedly ruled that prayer in the schools violates the First Amendment. Given your statement in 1985, could you explain your views on prayer in schools today?
Senator, as I indicated yesterday, my comments there were not taken to in any way reflect on the legal rulings on the Establishment Clause or the Free Exercise Clause. As I indicated yesterday, that from my standpoint as a citizen of this country and as a judge, that the metaphor of the Jeffersonian wall of separation is an important metaphor. The court has established the Lemon test to analyze the Establishment Clause cases, and I have no quarrel with that test. The court, of course, has had difficulty in applying the Lemon test and is grappling with that as we sit here, I would assume, and over the past few years. But the concept itself, the Jeffersonian wall of separation, the Lemon test. Neither of those do I quarrel with.
All right. In your view, Judge, what is the current state of the law with regard to the Establishment Clause of the First Amendment?
The court now, in the application of the Lemon test, and that is that there be a secular purpose to the legislation or the action, that there be no primary sectarian effect, and that there be no unnecessary entanglement of government in the affairs of religion. It's been difficult for the court, as I noted, to apply. The court has been split between, I think, those who feel that there should be some accommodation and those who think there should be an absolute separation. The Justice O'Connor, of course, has offered some movement in the area, as well as the Justice Kennedy, I think, has applied a coercion test. I think the judges are grappling at when church and the government are inexorably in contact with each other, how much separation can there be, and how do you draw the line? I think it's difficult. It's been difficult for the court. We see it in the cases with the Christmas displays. The court has not resolved it, but I think the analysis, the Lemon test, as well as the understanding that the separation must be there is important, but in practice it's difficult.
How do you equate your willingness to discuss this area of the Constitution, which is a basis of unsettled law, with your unwillingness to discuss another area of the Constitution, which is a woman's right to choice?
Senator, I think what I have attempted to do is, to the best of my abilities, without judging or prejudging the case, to simply set out in an area that you have requested the analysis of what the court has done and where it has gone. I have indicated, and I think it's important to indicate, that the area of Roe v. Wade is a difficult, it's a controversial area. Cases are coming before the court in many different postures. And I think it would, and I think a judgment that each member of the judiciary has to make, I think it would undermine my ability to impartially address that very difficult issue if I'm confirmed to go further than I've gone.
Finally, Judge, with respect to all the things that you've said and written in the past, and the things that you have asked us to discount today, I'm thinking also about the meeting we had in my office when you said that we should, for the most part, forget about what we've read and written about you, that the real Judge Thomas will come out at the hearing. My question is, why is it inappropriate for us to make an evaluation of your candidacy based upon all the things that you've written and said, particularly in view of the fact that you've been on the court for only 16 months? If we are going to make an informed judgment on behalf of the American people, why are not your policy positions important? How are we supposed to make a judgment on you? Is it fair for you to say to us, for the most part, members of the panel, just view me on what I'm saying here this week. Don't view me on what's been written about me, about my speeches, about the things that I've said. Does that give us the most complete opportunity to make the evaluation that we need to make in behalf of the American people?
Senator, I think that I have turned over and responded to requests has resulted, I think, in 32,000 pages of documents. I've spent the last decade in the government. I think that the material is there. I think that a fair reading of my record is a reading which indicates that I am one person who's attempted to be involved and attempted to do some good, who did not not hide, who did not shrink away from the problems, who tried to grapple with them, who tried to take them head on, and who tried to make a difference. And I think the record is relevant. But I think it has to be understood that when I was in the executive branch, I was in the executive branch. I'm a member of the judiciary. And I think it's a fair question for you from me to you, is to see whether or not my policy positions have tainted my role as a judge.
Well, you've only been on the court for 16 months, and so it really is, we're not in a position to see how your policy positions are either consistent or not consistent with the things that you've done on the court. But in many areas, as you said, that some of the policy positions you've taken in the past, you're asking us to recognize were just that, policy positions, and they would not, they don't have any relevance to your court experience or the court kind of experience or expertise that you bring to the Supreme Court. I think in telling us, you, for example, say you turned over 32,000 pages to us, and yet when we come back to you and say, well, what about this or what about that, you're saying that doesn't count or that doesn't count. I guess the question I'm asking is whether or not you would have us evaluate. In your opening statement, for example, for the most part, what it said is that you are an example of a person who has pulled himself up by the bootstraps, who is a good, honest, decent, hardworking, effective, intelligent man, which you are in spades. And I think to an extent that troubles me somewhat, your hearing has been a continuation of that kind of an experience in a past and a history and an encouragement for us to judge you on. And I think that we and the American people, Judge Thomas, should be given the full opportunity to judge you on the whole range of your life experiences, which does include the things that you have said and written and done, just like it does for the rest of us. When I ran for office, I wasn't able to say, don't consider this or don't consider that. The voters wouldn't allow that. I mean, they consider everything I've done, everything I've said. And I think that that's the way the process should work in a democracy. And to the extent that you think I'm exaggerating, I'd be interested in your response, and then I'm finished.
Senator, I think that if this were an oversight hearing, that I could go back and discuss all the policies and tell you that, yes, it's relevant to me going back and running my agency, or running the agency that I have been asked to run or permitted to run. When one becomes a judge, the role changes. The roles change. That's why it's different. You're no longer involved in those battles. You're no longer running an agency. You're no longer making policy. You're a judge. It's hard to explain some, perhaps, but you strive. Rather than looking for policy positions, you strive for impartiality. You begin to strip down from those policy positions. You begin to walk away from that constant development of new policies. You have to rule on cases as an impartial judge. And I think that's the important message that I'm trying to send to you, that yes, my whole record is relevant, but remember that that was as a policymaker, not as a judge.
Thank you, Mr. Chairman.
Thank you. Judge, before I begin my questioning, I'd like to point out for the record, there are 32,000 pages of documents, but I would guess 31,000 pages of those have nothing to do with what you've written, nothing to do with what you said. They're agency documents. So the implication should not be left here that anybody has questioned you on even a remotely large part of those 32,000 pages. All you've been questioned on so far, and all I think the Senator was making the point about, is that we're trying to figure out, as you said, how you would rule. We don't want to know how you rule on cases. We want to know how you think about ruling on it. And all the questions asked of you, none of them thus far have had anything to do with 32,000 pages of documents. They have to do with probably, if you added up all the speeches you gave, it would give us insight into how you think. Maybe there's 1,000, maybe there's 500, maybe there's 1,200 pages, but that's what we're talking about. And I know you know that. I just want to make sure that the public doesn't think we're you have to go back and look over 32,000 pages of documents and how to analyze it. That's sort of the Wall Street Journal argument. This has nothing to do with 32,000 pages of documents. Now, Judge, I want to see if I can come away from this round of questions with a better understanding of the method, not the result, the method that you would apply to interpreting the very difficult phrases in the Constitution, which have been phrases that have been matters of contention for 200 years or more, and when interpreted, have sent the country off in one direction or another. Now, you'd be pleased to know I don't want to know anything about abortion. I don't want to know how you think about abortion. I don't want to know whether you ever thought about abortion. I don't want to know whether you ever even discussed it. I don't want to know whether you talked about it in your sleep. I don't want to know anything about abortion. I mean that sincerely, because I don't want that red herring, in my case at least, to detract from what I'm just trying to find out here, is how do you think about these things? When you and I talked on Tuesday, you said, and I quote in this hearing, "I don't see a role for the use of natural law in constitutional adjudication. My interest in exploring natural law and natural rights is purely in the context of political theory." Now that struck me as something different than you said in many speeches, and I gave you some of those speeches yesterday so that you'd know what I wanted to talk about today, and you know I want to talk about this subject with you so I can understand it better. So let's start with what you not said in the speeches, but what you told the committee so far about whether natural law does or does not impact on the Constitution. Yesterday, you told us that the framers of the Constitution, quote, subscribed to the notion of natural law, end of quote. But you emphasized that any such belief, any belief held by the framers based on natural law, had to be reduced to positive law, that is, put in the Constitution for it to have any effect or impact on adjudication. The framers, you said, sometimes, quote, reduced to positive law in the Constitution aspects of life principles they believed in. For example, liberty. But when it's in the Constitution, it's no longer natural rights. It is a constitutional right, and that's an important point. So as I heard that statement, I began to think I'm beginning to understand your thinking on this, but I want to be sure. Do you recall saying that yesterday?
I generally recollect that.
And is that a fair rendition?
I think it is.
Then you went on to say, and I quote, positive law is our Constitution. And when we look at constitutional adjudication, we look at that document. Let me have a copy of the Constitution. So it is purely positive law. It's purely that Constitution, this document. When you as a judge are interpreting it, the fact that the framers based the Constitution may or may not have based the Constitution on natural law, and you and I think they did, that does not impact on adjudication unless it was reduced to writing in the Constitution. And then it's positive law. That's what you mean by positive law, right?
That's right.
Now, and so it's purely positive law that you as a judge look to in order to decide a case. Is that right?
I think I indicated in later testimony, and this is an important point, and it's one, as I read your op-ed piece, is one that I think you ask in a different way. You say, is it rigid, or is this concept of natural law rigid? For me, that question would be, is the concept of liberty rigid? And in our constitutional tradition, the concept of liberty is a concept that has been flexible. It's one that has been adjudicated over time, looking at history, tradition, of course, starting with what the founding fathers thought of the concept of liberty, but not ending there.
Okay. I'm beginning to understand. So, natural law informs the notion of liberty. You and I have both read, because of our backgrounds, I suspect, we both read, I won't get into Aquinas and Augustine and all of that, but Locke looked back to the concept of natural law as an evolving notion. Montesquieu talked about it. Jefferson understood it. He was in Paris. He's probably the only one that fully understood it. But others who were there writing the Constitution, they talked about it. They had what they wrote, both the Declaration, as you say in other places, and in the Constitution. They reduced these broad notions of natural law, the natural rights of man, to this document. Now, you say that they put some of these natural law principles in the document, and words like liberty you just mentioned, you indicate that once liberty was in the Constitution, it becomes positive law. But now comes the hard question, as you and I both know. A judge has to define what liberty means. Now, how does a judge know what the ambiguous term liberty means in the Constitution? And I want to start with a key term in the Constitution, one that protects the right of privacy and many other rights. And that's the word you mentioned yesterday, you mentioned again here today, liberty. Yesterday you told the committee, our founders and our drafters did believe in natural law. In addition to whatever else, philosophers they had, and I think they acted to some extent on those beliefs in drafting portions of the Constitution. For example, the concept of liberty in the 14th Amendment. So the concept of natural law, liberty, is embodied, you say, and I agree with you, in the 14th Amendment. You also then said, to understand what the framers meant and what they were trying to do, it's important to go back and attempt to understand what they believed, just as we do when we attempt to interpret a statute that is drafted by this body, to get your understanding, end of quote. Now, as I understand this, Judge, while you reject any direct application of natural law, that is you sitting there and saying, I think natural law means, therefore, I rule. Even though you reject the direct application of natural law in constitutional adjudication, you would use natural law to understand what the framers had in mind when they interpreted these broad notions. Isn't that correct?
Not quite, Senator.
Okay.
Let me make 2 points there. The framers' view of the principle of liberty is the important point.
Right. Okay.
Whatever natural law is separate and apart. The important point is what did the framers think they were doing? What were their views?
Gotcha.
The second point is this. That is only a part of what we conceive of this notion in our society. The world didn't stop with the framers. The concept of liberty wasn't self-defining at that point.
Right.
And that's why I think it's important, as I've indicated, that you then look at the rest of the history and tradition of our country.
I agree with you completely, which may worry you, but I agree with you completely. Now, as a matter of fact, you use that argument to take on the original intent people in some of your speeches. You basically say, hey, you folks who just go original intent and are pure positivists, you got to look at intent, and real intent of these guys is not just static. It goes on. It's informed by changes in time. And also, you got to understand, as I understand you, that they used the word liberty because they believed it to be a natural right of man. I mean, to be specific, you say, and it's what you said here, our founders believed in natural law, but they reduced the natural law to positive law. And one of those concepts in natural law they reduced was liberty to positive law, because the word liberty appears in the Constitution, in the 14th Amendment in particular. Now, In a speech before the Pacific Research Institute, which we gave you yesterday, you praised the opinion of Justice Scalia in Morrison v. Olson. That's the case where the Supreme Court upheld, as you know, 7-1, the right of the Congress to say there can be a special prosecutor like Walsh, like the Iran-Contra. It wasn't about Iran-Contra, but the special prosecutor. But Scalia filed a lone dissent, and you praised his dissent, and you said the following: Justice Scalia's remarkable dissent in Morrison points the way toward the correct principles and ideas. He indicates how, again, we might relate natural rights to democratic self-government and thus protect the regime of individual rights. You go on to say that that principle means that the principles and ideas indicated by the opinion and the Massachusetts Bill of Rights, which you quote, refers to, quote, and you're referring now, you say, summarizes well the tie between natural rights and limited government. Beyond historical circumstances, sociological conditions, and class bias, natural rights constitutes an objective basis for good government. So the American founders saw it, and so should we. But we don't. Try talking to a Justice Department attorney about natural rights. And when you mention the venerable term, they assume that you're an activist, that you want an activist court along the lines of Mr. Justice Brennan. That such an assumption must be fought reveals the extent to which the term natural rights has been corrupted and misunderstood, and not only among the class of conservative sophisticates in Washington. Now, I don't know any other way to read this passage than to conclude that you believe that natural law and natural rights should help judges decide constitutional decisions.
No, Senator. I've said that I've repeated that continually here.
No, but
Senator,
it doesn't jibe.
But Senator, I was speaking as a chairman of EEOC, and let me explain to you what my interests were. I have under oath in my confirmation for the Court of Appeals and for this court, tried to explain as clearly as I possibly could what I was attempting to do. Speech after speech, I talked about the ideals and the first principles of this country, the notion that we have three branches so that they can be in tension and not impede on the individual. That's what this case is about. At bottom, the case is about an individual who could be, in some way, whose rights could be impeded by an individual who's not accountable to one of the political branches. That was the sole point.
I understand the point.
I have not, in any speech, said that we should adjudicate cases by directly appealing to natural law.
What was Scalia doing?
Senator, I think
adjudicating a case, wasn't he?
He was pointing out the relationship, the purpose of the relationship among the branches.
Right, but Judge, wasn't the reason he was pointing it out, if we need be, we'll spend all day Friday on this, wasn't the reason he was pointing this out because he wanted the case adjudicated, decided in a way differently than the 7 justices who decided it in favor of the existence of, the constitutionality of. He was adjudicating. Now, what is this? It seems like we're engaged in a little bit of sophistry here. Wasn't he adjudicating the case?
He was adjudicating a case. I am only pointing to, as I say here, the concern that I had between the relationships in the branches. If, Senator, I, as a sitting federal judge, had written this speech, considering the fact that I adjudicate cases as a sitting federal judge, and did not draw a clean distinction between a speech that is talking generally about the protection of individuals then I think you have a very valid point.
What did Scalia do, Judge? Didn't Scalia do just what you said? Scalia applied natural rights in making a decision before the Supreme Court of the United States of America. You say that's what he did, and you recommend to everyone else, look at what he did.
Senator,
it's a good thing.
Senator, I beg to differ.
Okay.
I have attempted in good faith and under oath twice to make clear that I don't think that an appeal and a direct appeal to natural law is a part of adjudicating cases. Now, the point that I was attempting to make here, as I indicated to you, is simply he indicates how, again, we might relate natural rights to democratic self-government.
That's what he was doing.
Relate. I didn't say adjudicate cases. Senator, I am interested. I was interested in the notion that you have the three branches of government.
Right.
And you have an individual. Now, let me give you an example of my point, talking about the ideal. I think that we agree that the ideal that all men are created equal is an ideal. It is certainly one that was in our Declaration.
Is it based on natural rights?
It was based on our founders' belief in natural rights.
Right.
But slavery existed even as that ideal existed.
Right.
That did not mean that slavery was right or comported with that ideal. It did not mean that you could end slavery without a constitutional amendment.
Agreed. That's the point, Judge. The point is, you say, our founders looked to natural law to inform what they put in the Constitution. But it doesn't matter. The fact they said all men are created equal didn't mean anything until the 13th and 14th Amendments to stop slavery. But once they put it in, this natural law principle, in 1866, it became part of the law. Now, we have to treat it as law. But because it is uncertain what that means, for example, does all men mean all women? That's what the 14th Amendment was about. We've concluded it does. Because we don't know what it means, because it's broad and ennobling, we have to go back, you said, and look at the framers and what they meant.
As a starting point.
As a starting point. So at least, Judge, will you not acknowledge you conclude that natural law indirectly impacts upon what you think a phrase in the Constitution means?
To the extent that to the extent that the framers believed comport with that.
But the framers
But
thought natural law meant.
the important point is what the framers believed. For example, I think I said in trying to find the precise statement here.
Take your time. We have a lot of time. Really, take your time.
I think in referring in the speech toward a plain reading of the Constitution,
I read it.
I indicate that Harlan's dissent relies on his understanding of the founders' arguments,
Right.
not some direct appeal to any broad law out there that we don't know.
But how did he figure out what the founders meant by natural law?
Again, I think, Senator, you look at the debates, you look at whatever it was that Harlan had available to him. There's not an explicit direct reliance on anything other than what he could find the founders meant.
Right.
How do we look at history and tradition? How do we determine how our country has advanced and grown? It's a very difficult enterprise. It's an amorphous process at times, but it's an important process.
Well, that's the one we're trying to find out you use, Judge. For example, before I leave the Pacific Research speech, let me digress for just a moment. In that speech you said, and I quote, "Conservative heroes such as the Chief Justice failed not only conservatives but all Americans in the most important case," that's Morrison, "the most important case since Brown versus the Board of Education. I refer, of course, to the independent counsel case of Morrison." And you said the Morrison case upheld the constitutionality of independent counsel, it should have, which did uphold it. You thought Scalia was right that it shouldn't have upholded it. Now, Judge, why is the case upholding the legality of an independent counsel the most important case since Brown versus the board?
Senator,
A lot of important cases, Baker and New York Times and the Pentagon family.
Well,
why is that one? Just out of curiosity.
Well, the reason that I used that approach was it was, for most people, it had to do with an obscure point on the separation of powers. That doesn't exactly excite people in an audience. The point was, though, that I was trying to indicate to them is that when we address cases involving the structure of our government, there is a subsequent impact, or it could have a direct impact on individuals. And I think that's the point that I made in the speech, and that was the central part of the speech. It was not an exegesis of the Supreme Court opinion itself, but how it affected the relationship of the government to individuals. And again, it's a point that I'd have to make again, Senator, that underscores much of the discussion of natural law. It has to be understood that I took on this endeavor as the chairman of the EEOC because of my general view that the last great person who was able to inspire our country toward an ideal was Martin Luther King. And the notions of the poor treatment of people in our society.
I agree with you, Judge.
But it was not an effort, as I indicated in my confirmation hearings for the Court of Appeals, to establish a constitutional philosophy,
Judge,
to adjudicate cases.
Well, Judge, I don't know how you can possibly say that, since you say the framers, let's just stick to liberty. The framers put liberty in the Constitution because they thought it was a natural law principle. They put it in the Constitution. It became positive law. Nobody knows what liberty means for certain. So judges today have to go back and look what the framers meant by it. How you cannot examine what their view of natural law was in order to know what they meant is beyond me. But
Well, that's the point. We agree there.
Okay, we agree. All right, now.
That's for starters. Though.
Okay, so you're going to apply, at least in part, the framers' notion of original intent, of natural law, right?
As a part of the inquiry.
As a part, okay. Now, so how do we know what the framers of the 14th Amendment had in mind when they said liberty? How do we know they had the same version of natural law in mind as, say, the framers in 1789 when they talked about all men are created equal in the Declaration and then enshrine that principle in the Constitution later? How do we know?
Well, Senator, again, I have not used or interpreted that provision in the context of adjudication, but the important starting point has to be with the debates that they were involved in, and their statements surrounding that debate.
And the debates, don't they use phrases like God-given rights and they came from God, and don't they use those phrases? I read them.
But let me move forward. I also indicated that the concept doesn't stop there. It's not frozen in time. Our notions of what liberty means evolves with the country. It moves with our history and our tradition.
All right, well, Judge, if tradition and history, what happens if the tradition and history conflicts with what you and I would believe to be the natural law meaning that the founders had at the time,
Uh,
even though it's been reduced to positive law. The word liberty was reduced to positive law in 1866. Tradition and history demonstrated when that happened, for example, women didn't have the right to vote. Women were not allowed to be everything from lawyers to whatever. So you look at tradition and history and you conclude, obviously, they didn't have women in mind, yet when you look at the natural law principle they had in mind, they must have had women in mind when they talk about all men and the rights of individuals. Now, when they conflict, natural law, underpinning of the founders or the framers of that amendment's notion, and history, which do you choose?
Senator, let me make that point, or let me address that by saying this. The concept is a broad concept.
Right.
And the
That's
point,
the problem.
Yeah, that's it. But maybe that's one of the reasons the founders used that concept. It is one that evolves over time. It is one, I don't think that they could have determined in 1866 what the term in its totality would mean for the future. But in constitutional adjudication, what the courts have attempted to do is to look at the ideals, to look at the values that we share as a culture, and those values and ideals have evolved in that specific provision, has evolved over
In
time.
a lot of other provisions, they've evolved too, Judge.
Well, but in that provision,
Sure,
it's
in
evolved.
liberty. Let's just stick to the liberty clause. They've evolved. Now, some argue, a number of very distinguished jurists before us argued, that evolution of those views should be bound by the history and their tradition, and Justice Scalia, who you quote often, fundamentally disagrees with your view about going back and looking at the natural law tradition. You said, for example, yesterday, that there's a right to privacy in the 14th Amendment, and it was made clear that this is a marital right to privacy. Now, Judge, I assume you find that right in the Liberty Clause, this right to privacy.
The liberty component of the due process clause.
Right. Now, let me ask you this. If I can move along, light of my time here, the discussion of this question yesterday about right to privacy. Yesterday, with Senator Leahy, you told the committee, I quote, "I believe the approach that Justice Harlan took in Poe versus Ullman and have reaffirmed again in Griswold in determining the right to privacy was the appropriate way to go." Is that correct?
That's what I said, I
Okay.
believe, yesterday.
Now, I find this still harder to understand in light of the fact that Justice Harlan in Poe relied specifically on natural law. Let me read the quote to you. He says, "It is not the particular enumeration of rights in the first 8 amendments that spells out the reach of the 14th Amendment's due process, but rather it was suggested in another context, long before the adoption of that amendment," meaning the 14th Amendment. "It is those concepts which are considered to embrace rights," quote, subquote, "which are fundamental and which belong to all citizens of a free government." And he's quoting the Corfield case there. Now, Justice Harlan reaches his judgment based on natural law. And he quotes the Corfield case, which I might add, Judge, as late as, this isn't something new, as late as 1985 in the Rehnquist court. They quote the Corfield case as well. So you say, this is what confuses me, you say natural law is no part of adjudication of a case. You
to the
rely
extent.
on, let me just finish, and you can tell me how I'm wrong. You rely on Justice Harlan in Poe as the rationale as to how you find a right to privacy in the 14th Amendment. Justice Harlan adjudicates that there is a right because it is a natural right. And you say natural rights have no part of the adjudicating process of whether or not the word liberty means A, B, or C, or any other provision of the Constitution that we have difficulty understanding means anything. Explain that to me.
You missed an important point,
Maybe
maybe I'm not making myself as clear as I could be. What I said was this, that there is no independent appeal to natural law.
What do you call Poe?
What one does is one appeals to the drafters' view of what they were doing, and they believed in natural law. What were their beliefs? And one moves forward in time.
Let me stop you there for a second so I understand that, okay? I'm not trying to confuse you. I'm trying to understand. The drafters had different views of natural law. You and I both know that. Some agreed with the Thomistic view, not Thomas, who's been up for, not you, Thomas Aquinas. Some agree with the Thomistic view. The natural law is not revealed all at once, but natural law is a process that reasonable men, reasoning together over time, will determine what it is. Others believe, more in the Augustine tradition, he didn't call it natural law, that it's revealed. God just sent these down on high, and some people believe that it's even de fide doctrine, boom, infallibility. This is the law. They had different views. Now, you're saying you've got to go back and look at what their view of natural law is. How do you determine which view it was?
Well, I think it's difficult in any enterprise when you attempt to determine what other people were trying to do. But I think the important point that has to be made...
It's subjective, isn't it, ultimately?
It's an important point, and it's a difficult point, and it's a difficult determination. Just as it's difficult to determine after that how our tradition and our history and our culture evolved, and what are the underlying values. I think that is the point that Justice Harlan and others have attempted to make, that it's not to constrain the development of rights that you would want this adjudication being tethered to our history and tradition, but rather to restrain judges.
Judge, Justice Harlan had no problem. He didn't have your problem, this torturous logic, which I think borders on well, anyway, this torturous logic. He had no problem. He went straight to the heart of it in his dissent. He said, you don't look to any one of the amendments to inform, or all of the amendments to inform the 14th. Harlan, I don't have that problem, he says to the world. I go straight to natural law. And by the way, I'm not the first one to do that. In Corfield, they did that. And you say, you base your conception of privacy in the Liberty Clause based on Harlan and Poe. And now you're telling me that you don't think natural law plays it. He didn't fool around. He went right to the heart of the matter.
What I said was, again, Senator, is that one goes to what the founders and the drafters believe.
And he
you don't just, as you indicated, that there were competing notions of natural law. I think it is an important, though difficult, inquiry, and that it is one that the court undertakes, as well as the subsequent development and expansion and growth of the liberty component of the due process clause through referring to history and tradition.
All right, well, Judge, I don't know why you're so afraid to deal with this natural law thing. I mean, I don't see how any reasonable person can conclude that natural law does not impact upon adjudication of a case if you're a judge, if you acknowledge that you have to go back and look at what the founders meant by natural law, and then, at least in part, have that play a part in the adjudication of the outcome.
I am admitting that.
Pardon me?
I am admitting that.
Oh, you are admitting that? Oh.
And I have. I said
Okay, good. So natural law does impact on the adjudication of cases.
To the extent that the framers believe.
Good. But we both admit, you looking at the framer and me looking at the framers, we may come to two different conclusions of what they meant by natural law.
But we also agree that the provisions that they chose were broad provisions that adjudicating through our history and tradition, using our history and tradition, evolved.
All right, let me move on. I'm trying to get through this quickly as I can here. Judge, if you're confirmed, you would go about interpreting the Constitution prior to Tuesday, I thought, and now I understand, with natural law at least playing some part as you described it. Now, that still leaves me in the dark about how you'd interpret the broad principles of the Constitution in terms of what kind of natural law informed our founders. And as to whether the right of privacy protects certain family and personal decisions or it doesn't. As you point out, after all, the 14th Amendment is broadly phrased. It speaks of liberty and of due process. Now, the court has used this broad language in the past, the court, Supreme Court, not the founders, to recognize that certain types of personal decisions about marriage, child rearing, and family are fundamental to liberty. That's the phrase they use. That means that government must have an extraordinary, as you know, or compelling reason for interfering with the decisions. I'm not talking about abortion. I don't want to talk about abortion. I will answer no questions on abortion. All right? Now, do you agree that the right to marital and family privacy is a fundamental liberty?
Yes.
Now, let me ask you a second question. You have written a great deal about the rights of individuals as opposed to group, belonging to that human rights, natural rights, positive law rights apply to individuals, not to groups. And in fairness to you, you've done it almost always in the context of talking about civil rights as opposed to civil liberties. That doesn't mean exclusive of civil liberties, but you've made your point about affirmative action, quotas and other things through that mechanism. Now, am I correct in presuming that you believe that the right of privacy and the right to make decisions about procreation extend to single individuals as well as married couples? The right of privacy.
The privacy, the kind of intimate privacy that we're talking about, I
The
think...
right about specifically procreation.
Yes, procreation that we're talking about, I think the court extended in Eisenstadt v. Baird to non-married individuals.
Well, that's a very skillful answer, Judge. Judge Souter, and I was not fully prepared when he gave me the answer. I am now. Judge Souter waltzed away from that by pointing out it was an equal protection case. So that I want to know from you, is this the single individual, not married couple alone, have a right of privacy residing in the 14th Amendment Liberty Clause?
Senator, the courts have never decided that, and I don't know of a case that has decided that explicit point. Eisenstadt was, of course, decided as an equal protection case. And
not alone, but go on.
My answer to you is I cannot sit here and decide that. I don't know.
Why can't you? That case is an old case. I know of no challenge before the court on the use of contraceptives by an individual. I can see no reasonable prospect there's going to be any challenge. And, Judge, are you telling me that may come before you? Is that the argument you're going to give me?
Well, I'm saying that I think that for a judge to sit here without the benefit of arguments and briefs, etc., and without the benefit of precedent,
Okay.
I don't think anyone could
Well,
decide
Judge,
that.
I think that is the most unartful dodge that I've heard, but let me go on. Judge, I think the decision in Eisenstadt, and so do I think most scholars, think it stands for a much broader principle beyond equal protection. Let me read to you from Eisenstadt, the majority opinion. The marital couple is not an independent entity with a mind and a heart of its own, but an association of two individuals, each with a separate intellectual and emotional makeup. If the right of privacy means anything, it is the right of the individual, married or single. Stop here. Same point you make about civil rights. Individual. Back to the quote. If the right of privacy means anything, it is the right of the individual, married or single, to be free from unwarranted government intrusions into matters so fundamentally affecting a person as a decision whether to bear or beget a child. Many Supreme Court cases since then have been decided using the ruling in 1972 that I referred to, using this basic principle. So for the time being, let's put aside equal protection again, Judge, and focus on the more sweeping question of the right of privacy. And I ask you again, do you think that single people have a right to privacy anchored in the Liberty Clause of the 14th Amendment?
I think my answer to that, Senator, is similar to my previous answer, and it is this, that the court has found such a right of privacy to exist in Eisenstadt v. Baird, and I do not have a quarrel with that decision.
So you don't quarrel with the quote I just read to you?
I don't quarrel with the decision in Eisenstadt v. Baird.
That's not the question I'm asking you, Judge. Do you quarrel with the quote that I read you from the majority opinion?
I don't quarrel with the quote.
Do you agree with the quote? Let me ask you that way.
Well, let me...
this is getting more like a debate than it is getting information.
The important point that I'm trying to make, Senator, is that the case was decided on equal protection basis.
I understand that.
I do not quarrel with the value that you're discussing. I do not quarrel with the result in the case.
Judge, I'm not looking for your values because I know you're not going to impose them on us. I'm not looking for your judgment on the case, whether it was equal protection. I'm asking you whether the principle that I read to you, which has in fact been pointed to and relied upon in other cases, is a constitutional principle with which you agree, which is that single people have the same right of privacy, not equal protection, privacy, as married people on the issue of procreation.
I think that the court has so found, and I agree with that.
All right. Now, let me ask you this. Are there... my time's going real well, Senator. Thank you. I don't have any idea. Just like you, I'm looking at that little clock, and when it gets... some impartial person that works for me, Senator. Back there.
I was afraid of that.
That's what I thought. Now, you said that the privacy of right of married couples is fundamental, and as I understand it now, you told me, correct me if I'm wrong, that the privacy right of an individual on procreation is fundamental. Is that right?
I think that's consistent. That's consistent with what I said, and I think consistent with what the court held in Baird v. Eisenstadt.
All right.
Eisenstadt v. Baird.
Just so we don't have any problem here, I think your friends think you're getting in trouble, and they'd like me to stop. So what I will do is I will stop now.
Go ahead.
Well, Chairman Danforth suggests we can go forward. But if you would, if we've gone over the time of a half an hour, we should stop. And if not, I'd be delighted to keep going, because I'd like to now talk about another phrase in the Constitution.
Do it like that, because when I started this hearing, I emphasized the issue of fairness, and that's what this is. Every
If
one of
I
us...
have gone over 20 minutes, half an hour, I should stop.
I can assure you you have. You've gone about 35 or 40 minutes.
All right, if I've gone 5 minutes over, then I stop. Thank you very, very much. And I want to assure you, there's no plot back there, Judge, notwithstanding what my friends may think. But thank you very much. I think I've learned a lot more about what you think, and I want to come back, and just so you know, so there's no surprise, I'm going to come back and talk about other provisions of the Constitution which we don't understand the exact meaning of. I don't mean just we, the universe of lawyers. Thank you very much. I yield now to the distinguished senator from South Carolina, and if I've gone over any time at all, add that time to the senator from South Carolina's time. Oh, I'm sorry. It's been suggested that that it'd be appropriate time for there be a 10-minute break. We'll recess for 10 minutes. Did I go over?
And so there's a brief recess at this morning's session of the Senate Judiciary Committee. This is the third day of hearings on the nomination of Judge Clarence Thomas to be a member of the Supreme Court to succeed the retiring Justice Thurgood Marshall. The senators are gathered around the head table. Senator Biden talking at the moment with Senator John Danforth, the Republican from Missouri, who is the chief supporter for Judge Thomas's nomination here in the Senate. John Danforth was the man who brought Judge Thomas to Washington, and Judge Thomas again is accompanied by his wife and his son to this third day of hearings. Thus far, Judge Thomas has been in the witness chair for approximately a little over 11 hours. And the likelihood is that he will be in the witness chair the remainder of today and on into tomorrow in a hearing process that is expected to go on for approximately 2 weeks. The hearing's taking place in the historic old Senate caucus room on Capitol Hill. And
Paul, you know, we heard...
Nina, what I wanted to ask you, if I can put the question to you, because you've been sitting in the hearing room, but we had a long colloquy this morning between Senator Biden, who returned to his favorite subject, the issue of natural law. And I thought this was one of the most interesting exchanges that we've had thus far between the senator and Judge Thomas. And I thought he did begin to draw out Judge Thomas a bit more on his judicial philosophy.
He did. This is such an amorphous subject that it is
amorphous in something that a layman like me doesn't totally understand. So maybe we should explain again what we're talking about here with natural law.
Natural law is the concept that there are higher values, God-given values, that supersede what government can give to individuals, that they exist because individuals exist. Now, certainly natural law was a concept that was embraced by most of the founding fathers. It came into some disrepute in the legal world as a per se legal doctrine because it was used both to justify slavery and to get rid of slavery. It was used to justify discrimination against women and to strike down laws that discriminated against women. It was so amorphous that, in fact, the legal school that has most criticized the natural law view would be the school of thought represented by Robert Bork, who said that school of thought says if it's not in the words of the Constitution, it's not there. You've got to have words that say what you mean what you say. Now, liberals and conservatives have both adopted natural law concepts, but Clarence Thomas has embraced it in a perhaps more overt way than any nominee before him. He did that when he was, as he says, a sort of part-time legal philosopher or political philosopher. Now he's a nominee to the Supreme Court and a judge, and he says, well, this is different. When you're a judge, you cannot apply natural law. And this whole colloquy this morning was about when you can apply natural law only as a basis to inform our understanding, as he put it, of what the founding fathers meant by the concept of liberty. This is all a lot of words that take us round and round, but it's very important. It involves how we define what our freedoms are.
And it's important, too, because what Senator Biden is trying to do, he's trying to get at kind of the heart of the legal thinking of Judge Thomas and what his judicial attitude will be if and when he takes his place on the Supreme Court. I thought it was revealing at one point when Judge Thomas said the Constitution is not frozen in time, that this whole concept, that you've got to look at the natural law concept as something that moves with history and tradition. And that suggested to me, at least, that he takes a rather flexible view, even though Joseph Biden, of course, came back and said, well, people have different attitudes about how it should move. and so forth.
The problem with this kind of a debate, it seems to me, is that the words, many of the key words, are the same for everyone. There's hardly anybody who doesn't say that the Constitution is a living document that has to move with the times. Robert Bork would say that, as well as William Brennan. They would just say it in different ways when it comes to how to apply it in a particular factual situation. But the minute we get to a particular factual situation, a particular case, a particular issue, any nominee is going to say, well, gee, I can't comment about that because it may come before me. So there are limits to how much these senators can find out, because every time they try to really put some real texture on this whole business, their nominee slips away from it.
But they keep trying.
But they keep trying.
In any event. There is a break, a morning break at the Senate Judiciary Committee confirmation hearings on the nomination of Judge Thomas to the Supreme Court. And we're joined now by Ricky Silberman, who has been attending these proceedings. And Mrs. Silberman is an official at the Equal Employment Opportunity Commission who has worked very closely with Judge Thomas and is a friend of Judge Thomas of some years' standing. How do you think he's bearing up under all this?
Well, I think he's bearing up very, very well. I was interested in your comments this morning about Judge Thomas being programmed, and as someone who's known him for many, many years, I can tell you that Judge Thomas is not easily programmed. It is very difficult to program Judge Thomas. The gauntlet of esoterica that we have all listened to for, 2.5 days now, and that this morning, I guess, reached its apogee, if you will, I thought was very interesting, too, and excuse me, I call him Clarence because I think of him as Clarence, but Judge Thomas, he is my friend indeed, and I don't have any objectivity whatsoever about him, I have to say that. The talk about the confirmation conversion that's been going on today is the thing that has been of most interest to me, because anybody who knows Clarence, anybody who's worked with Clarence, knows that on all of these issues, this is vintage Clarence. It's been Clarence for a long time. Clarence is, his views evolve because he's very open-minded and because he has a great intellectual curiosity. And I have been fascinated with the whole discussion about natural law because I was there when he first started thinking about natural law and reading about natural law. And, you know, as he keeps trying to say, he was desperately trying to find a way during the bicentennial of the Constitution as an African American to justify the 3/5 clause in the Constitution and to justify the fact that slavery existed for how many years afterwards. So there's no confirmation conversion here.
I want to ask you a question. You've known him a long time. You are the vice chair of the Equal Employment Opportunity Commission and served with him in that capacity. Your husband is a judge on the D.C. Court of Appeals on which he served. Have you observed any difference in him when he changed jobs, when he went from the Equal Employment Opportunity Commission to becoming a judge?
Yeah, I think that's a very good and a fair question, and I think the answer is unequivocally yes. The role of a judge is very different than the role of the chairman of the EEOC, and I think that Clarence has, in the way that he looks at most things, looked at what it was that he was doing and how he could do it as the best person and in the best way that he can be. And that, you know, I think that's what's coming across with Clarence. He is coming across as Clarence now. He is so thoughtful, and he is approached, as far as I can tell, I haven't spent a lot of time with him as a judge, but he seems to approach that, and that's what's coming across in the hearing, in a very thoughtful and open-minded manner, and it's fascinating to watch for me.
Forgive me if I've got this wrong, but did you used to work for Senator Packwood?
I did.
Okay. Now, you worked on Senator Packwood's staff.
I was Senator Packwood's press secretary.
He is one of the 2 or 3 foremost advocates of the pro-choice position in the United States Senate. Do you know Clarence Thomas's position on this issue?
I do not, and that is also a good question. Clarence and I have talked about cabbages and kings and many things and natural law and a host of other things. We have never discussed abortion. We have never discussed Roe v. Wade. And we spent a lot of time talking.
Do you understand that most Americans, I think, would find that difficult to believe.
No, I think that's wrong, Nina. I think that, the issue of abortion is an intensely private issue that most Americans don't find that difficult to believe. I think those of us in Washington who spend so much time on the political nature of that issue find it difficult to believe because we spend a lot of time talking about it. But I don't think the average American spends a lot of time with even their good friends saying, well, do you believe in choice? I mean, I don't know about you, but I've had a couple of rather raucous dinner parties at my house when it came up, and we were all very happy when we moved on to another subject.
But it is one of the timely topics of our time, to say the very least, and I have been at dinner parties where it has been an issue that was just debated quite strongly, both pro and con, and it is unusual, I think, to see a man that has not only been a judge, but also has had strong opinions on other things and about the role of the government, that he would never have expressed himself on this most important issue.
I think it is a part of Clarence's feelings about privacy, if you will, the right of privacy. And I don't find it difficult to believe. The fact that these hearings so far have not strayed from natural law or abortion, it seems to me is maybe an indication of the fact that there are some other policy views that Clarence has that the senators may not want to engage in.
Speaking of affirmative
I
action.
am indeed of preferences, yes.
Do you feel that he could be doing a better job of answering some of the questions, because some of the Democrats have been suggesting now that he is stonewalling on certain issues, and they're disappointed that he's not being as forthright as they think he might be?
Well, I think that's a real political judgment. No, I don't. I think he's doing a wonderful job in answering questions. I think it's unfortunate that this process has become so politicized that there are certain issues that Judge Thomas or anybody else simply cannot talk about, not even ruminate about. I was shown yesterday something from Justice Marshall's confirmation hearings where he, with respect to Miranda and Escobedo, said, I cannot talk about this. And it is in the tradition of nomination proceedings. So I'm sure the Democrats are quite disappointed that Clarence is not being more forthcoming, but I think particularly on the issue of abortion, it is too controversial.
Well, you mentioned being programmed just a moment ago, and that is a word that you used. How much preparation did he undergo? How much training did he receive to be a witness?
I don't think that he received any training. What I know about is that Clarence retired to his home, where he did not answer the phone. He has call waiting on his phone, and not call waiting, but number identification. And he did not answer the phone. And as I know how Clarence does prepare for things, he went with stacks of briefing books. I was fascinated by his answer this morning because I know nothing of the process other than the fact that he was alone out in Virginia. I was fascinated by his answer where he set the ground rules. Clarence said in his opening statement he wanted the American people to see what makes him tick. And one of the reasons why I think the hearings are really going as well as I do is that I think that the picture of Clarence Thomas, which is coming across, of a man of integrity, intelligence, courage, these are all the qualities that I think are going to make him a great Supreme Court justice. And I think the American people probably are seeing that too.
And speaking of the man himself, we're told that he is now back in the witness chair. And so we assume the hearings will resume momentarily. But as we've seen so often, Nina, when they say they're going to take a 10-minute break, it turns into a 15-minute break or a 20-minute break. And there's Senator Biden still talking with Senator Danforth inside the hearing room.
We saw a little bit of a tip there a few moments ago when Biden had, in fact, exceeded his half-hour time, and he was asking a particularly hot line of questions, and the Republicans tried to get him to stop because he was over his time, and probably because it was dangerous territory, the whole question of procreation and privacy and contraception. And Biden said, well, if your guy's getting in hot water, I'll stop. If that's what you want me to stop, I'll stop.
Senatorial prerogative. That's right, Senator Simpson saying there was an issue of fairness here, and it's quite true that Senator Biden did go on in his questioning for about 40 minutes, and the process that they're following is one in which each senator has a round of questions for 30 minutes. Now, they will continue this until they feel that they've asked all the questions that they would like to put to Judge Thomas. Now, a bit more of a delay because Joe Biden has gone out to have a word with Judge Thomas.
Let me ask Ricky Silverman a quick question. We may have to cut you off, but what happens when they go back? I know that you must go back sometimes when Judge Thomas goes for these breaks. What do people talk about? What do they do to relieve the tension?
I haven't actually ever been there, Nina. I think they go right downstairs and get him a drink of water, and they probably show him the men's room. That may mean, he sits there for a long, long time. I don't sense a lot of tension, and I have sensed, I talked with Clarence a little bit over these last couple of days. He is, as he appears this morning, I think incredibly relaxed, considering the fact that he is undergoing this gauntlet of esotericism.
Does he feel the questioning has been tougher than he anticipated, or about what he anticipated?
He has not spoken to that. I think Senator Biden's first question, where he gave him part of a quote, and Judge Thomas was trying to remember what the rest of the quote was and didn't have it in front of him. I think he decided at that point that he wanted the text in front of him.
And there's the gavel, so we go back to the hearing.
Record. I was not referring to, when I said your supporters, I was not referring to the distinguished senator from Missouri or anyone from the White House or your family or you or your friends. I was referring to the intramural scuffle occasionally we get into here, and I want to make it further clear, there was no need we had agreed before we began that we'd break after two people. I wasn't suggesting, quote, you needed a break because of the relentless questioning. That was no part of it. It was the intramural scuffle that was going on here, which is all intramural scuffles are ended here because there's no problem, and as is always the case, if the senator from if I went over, and apparently I did go over, the senator from South Carolina and or any one of my colleagues on either side, I don't ever recall cutting anyone off when they've gone 35 minutes if they were in the line of questioning, and I won't do it now. They can have as much time as they want, and we'll break after two more for lunch, and we'll move on from there. I now yield to my yes.
Too, I want to clarify that I understand that the time and the lapse or the failure to terminate was totally inadvertent, and I want to state that. I understand that was an error. It did occur, but it certainly wasn't anything.
I think what happened was, remember when you were going through your book, I turned and said, hold the clock. And what happened was this clock is not what you'd call, the Navy Department would not use it for its instrumentation purposes. And that's what happened. We did go over 5 minutes. We're all squared away. 18 minutes? Well, Senator, you can have 53 minutes if you'd like. I yield to my friend.
I don't get them over. Just cut yours next time.
All right, here we go. Senator from South Carolina.
Yes, thank you, Mr. Chairman. Judge Thomas, in a 1988 article in the Harvard Journal of Law and Public Policy, you stated, and I quote, "To believe that natural right thinking allows for arbitrary decision-making would be to misunderstand constitutional jurisprudence based on high law." Now, the question is it your belief that cases that come before the court must be interpreted according to precedent, the law, and the Constitution?
That is the case, Senator. I think it's important for any judge to recognize that when he or she's engaged in adjudication that you must start with the text and structure of the document. And of course it's important in some of the open-ended provisions and constitutional adjudication to look to our history and our tradition. I think that the importance of doing that is not so much to restrain or constrain, as I said before, the development of important rights and freedoms in our society, but rather to restrain judges so that they do not impose their own will or their own views or their own predispositions in the adjudication process.
Judge Thomas, you said in your opening statement that you benefited greatly from the efforts of certain civil rights leaders. You further said that but for them, there would be no road to travel. Could you generally describe how you benefited by the efforts of certain civil rights leaders?
Senator, I speak with caution. I guess I've spent so much time on my own biography that it may be a matter of concern, but let me just make this point. There were any number of friends of mine whom I considered when I grew up to be much, much more talented. There were individuals who had enormous ability to remember, individuals who had tremendous capacity with numbers, and you wonder whether or not they would have gone on and become physicists or writers or business persons, what have you. But somehow, with the impediments that said you couldn't go to a library, that you could not go to certain schools, that you could not walk across certain parks, go into certain neighborhoods, impediments that said that you could be picked up and put on a chain gang for just standing on the corner. Somehow, with all those impediments, any number of them were prevented from moving on. Relatives, friends, my grandfather, a perfect example, enormously talented man. Unless someone removed those impediments, unless there was a civil rights movement, not all the talent in the world would get me here or get me actually even out of my neighborhood in Savannah. That's the point, that the civil rights leaders opened the doors, that the civil rights movement opened the doors that permitted individuals like myself to then move on. My further point was this, and that is that when others, either directly or indirectly in a broad or specific way, make the effort to create these opportunities, then I believe that I have an obligation, and I believe that others have an obligation, to repay them by taking full and complete advantage of those opportunities. As Martin Luther King said, we have to burn the midnight oil. And I think it's important to repay individuals with those kinds of efforts. And I've tried to do that, and I would encourage others to try to do that and remember those leaders and remember what they gave for us to have these opportunities.
Judge Thomas, I often ask potential judges for their comments on the topic of judicial temperament. How important do you believe this quality is in a judge, and what are your views on this topic?
Senator, I think it is important, actually critical, for a judge to be able to listen, to be open to the arguments, to be open to the different points of views, to look for all arguments on all sides, to explore them in depth, not to reject any. I think the essence of temperament is that receptivity and that openness. Because, as I said before, when the process is over, a judge has to feel that he or she got the decision right. And there's no better way to get it right than to allow the adversarial process to work to its fullest. And you can do that by having the temperament and the receptivity and the openness throughout the process. So I would say it is critical.
Judge Thomas, I noticed in your background that you worked with poor and indigent clients as a student attorney in the New Haven Legal Assistance Bureau, covering a broad range of legal issues. Some bar associations have debated the question of making pro bono representation mandatory. Aside from this issue, what are your views as to the importance of pro bono work?
Senator, I would look at pro bono work on two levels. First, the need of the individual. I think that there are individuals in our society who, for whatever reasons, and a variety of reasons, primarily socioeconomic reasons, cannot afford the kind of representation that they deserve or that they need. I think it is important for all of us in this society to feel that and to know that our judicial system is open to everyone, and the representation of poor or indigent individuals, I think, is critical to that, and it says a lot about our system. The second point is this. I think it is important, as I indicated earlier, for those of us who have gained so much from this society to give back. What I was attempting to do while I was in law school, as well as any number of friends of mine, is to take the opportunities, the abilities, the analytical skills, the energy that we had as law students, and to translate that into concrete help for people who needed things such as how to get their welfare check, how to get a pair of shoes, how to keep from being evicted, how to get their driver's license. Those are very basic things, and they may not be the sorts of things that will change the judicial landscape, but for those individuals, it was critical. And I felt a sense of satisfaction, a sense that I was giving back when I was able to work at New Haven Legal Assistance.
Judge Thomas, early in your life, you personally struggled to overcome difficult circumstances. You have prevailed over many obstacles to attain great success. As a result of this, are there any special qualities that you believe you would bring to the Supreme Court if you are confirmed?
Senator, the first, with respect to the opportunities that I've had and the help that I've gotten from other people, and as I noted in my opening statement, there have been just countless numbers of individuals who have helped me when I needed help. I can remember, for example, wanting to take a reading course and not having the money. And I remember someone, still to this day, someone I don't know, left $300 for me to take that reading course in 1970 or 71. So the people who have helped me have been countless. But if there's one thing that I have learned, is that you have to commit yourself to working hard, and you have to understand that that alone will not do it. But going to the court, and the experience that I would bring is something that I said earlier today, and that is that I feel that since coming from Savannah, from Pinpoint, and being in various places in this country, that my journey has not only been a journey in geographically, it has also been one demographically. It has been one that required me to, at some point, touch on virtually every aspect, every level of our country, from people who couldn't read and write to people who were extremely literate, from people who had no money to people who were very wealthy. So what I bring to this court, I believe, is an understanding and the ability to stand in the shoes of other people across a broad spectrum of this country.
Judge Thomas, the power of the judiciary is limited by Article 3 of the Constitution to cases and controversies. Its jurisdiction is not unlimited, as the court must decide disputes between parties. Could you please describe the limitations on federal jurisdiction and what role that would play in hearing cases before the court?
Senator, I think it's important for any judge to ask that critical question. what authority do I have or what jurisdiction do I have to review this case or to adjudicate this case. I think that that is important and that is critical in the judge being able to restrain himself and rightfully restrain himself. I do that myself, and in my own cases, either explicitly or implicitly, go through that sort of an analysis and self-questioning.
Judge Thomas, how would you resolve a conflict between your own conscience or your own sense of justice and the clear meaning of a statutory or constitutional provision?
Senator, if I was unable to adjudicate a case impartially, I don't think that, in fact, I would consider recusing myself from that case, and probably would, more likely would. I think it is essential that a judge be impartial. With respect to my own personal views, my views have no place. My personal views have no place in adjudication. The object of adjudicating a statute or interpreting a statute or applying a statute is to determine the intent of this body, the intent